Well, good afternoon. Welcome to Policy Exchange. It's my pleasure to welcome you here. If we've not met, my name is Richard Eakins. I teach law up at the University of Oxford and lead Policy Exchange's Judicial Power Project, together with my colleague Graham G. at Sheffield. Some of you will know the project, our particular focus is on the UK experience, but we've always been conscious that the rise of judicial power is a global phenomenon, and that the experience of other jurisdictions, especially in other parts of the common law world, is very important. And the project has aimed in part to recall the common law constitutional tradition, while being aware that various different jurisdictions are departing from it or qualifying it in various ways. And with this in mind, we've been pleased to publish contributions from judges serving on or recently retired from the Supreme Court of New Zealand, the Supreme Court of Canada, the High Court of Australia, as well as leading judicial figures from here in the United Kingdom. And the example of the Canadian courts is a particular force in the United Kingdom at times. In a speech in Ottawa earlier in this year, the President of our Supreme Court, Lady Hale, noted that Canada is probably the go-to jurisdiction when we, meaning the Supreme Court, are looking at comparative law. So much so, if we find we are departing from recent Canadian authority, we are troubled about it. So it may be an opportune moment for us to hear from a leading Canadian appellate judge, Justice Bradley Miller, who will be discussing some challenges in legal methodology and their constitutional consequences. Justice Miller was appointed to the Superior Court of Justice in Ontario in January 2015 and was elevated to the Court of Appeal for Ontario later in that year. He studied law in Canada and then again later in Edinburgh and Oxford, where he completed his DPhil. Justice Miller practiced commercial and constitutional litigation in Canada for many years and served from 2005 to 2015 as a law professor at the University of Western Ontario. He was an outstandingly able academic and remains very clever to this day, and his published work includes the collections The Challenge of Originalism, Proportionality and the Rule of Law, and he's also a co-author in the monograph Legislative Rights, published recently. It's a great delight to be able to welcome Justice Miller to Policy Exchange and to invite him to address us now.
Thank you, Richard. Well, I'd like to first off thank Dean Godson and Richard and Graham G for the invitation, and to all of you for coming today. It's a tremendous honor to be here. There's sometimes a reluctance to criticize the work of judges, but every public institution exerts power in one form or another and can benefit from intelligent scrutiny, and the courts, it seems to me, are no different. The Judicial Power Project has offered sophisticated conceptual analysis of the practice of courts in a way that I found to be at once constructive and accessible. And perhaps that's only because my court, the Court of Appeal for Ontario, doesn't often find itself in their crosshairs. But we all have reason, I think, to be grateful for the initiative of the Judicial Power Project. What I wanted to address today was a suite of doctrinal problems that are in Canadian courts share in common with the UK courts. I have narrowed that down to one, actually. So you'll be relieved that you will actually get back to your day jobs at some point. But I want to start at this point. In judicial reasoning, it often takes place in circumstances of uncertainty, where past acts of lawmaking, like case law, regulations, statutes, these past acts that are to guide judgment are underdetermined and leave open questions. And the problem can often be acute in constitutional adjudication, where the constitutional settlements that have been formalized in constitutional texts may be only partial and stated at such a high level of generality that they perhaps paper over underlying disagreement. So keeping the Constitution supreme is a challenge in the difficult circumstances of incomplete constitutional settlements. Ascertaining what the Constitution authorizes or requires or what constraints it imposes can be difficult even in the most favorable of circumstances. But where constitutional texts, and particularly bills of rights, are crafted using vague language, it falls to other institutions in acts of legislative, executive, and judicial decision-making to further specify what these vaguely worded rights will mean in the particular and how they'll bear on daily life. So courts play an important role here. They take the commitments that a political community has made through the constitution-making process and use them to craft legal rules or doctrines that can be applied to particular disputes. After all, constitutions aren't self-interpreting or self-applying, but some constitutional doctrines created by courts in Canada and elsewhere have proved especially prone to misapplication and provide unintentional support for an outsized role for the judiciary in making new constitutional commitments on behalf of the political community. And where lawyers and academics and judges grow overly comfortable with these doctrines through long acquaintance and acceptance, the underlying methodological weaknesses tend to be left unexamined or too easily excused. And the remedy is careful engagement with competing ideas, holding our most familiar doctrines under the spotlight and justifying them. This is a matter of both carefully articulating how these doctrines function in their own terms and attending with equal care to the case made against them. So there's several such doctrines in Canadian and English law, but today I want to look at one which in Canada has become close to constitutional bedrock. It's the practice of interpreting a constitutional or quasi-constitutional text as a living tree. Now this has an analog in the living constitution jurisprudence of the English courts and the European Court of Human Rights, though it is, I think, in some ways distinct. But before proceeding to consider the difficulties posed by living constitutionalism, it will help first, I think, to address two background concepts in constitutional theory, both related to the idea of a constitutional settlement. These are firstly the theory of coordinate interpretation, and second, the distinction between constitutional interpretation and constitutional construction. So on coordinate interpretation, constitutions, whether they're written primarily or unwritten, are products of political settlement, whether by formal agreement or by more informal usage and convention. And written constitutions, particularly, are intended to be difficult to amend. They establish institutions, confer authority and limit it, and set rules, standards, and norms to guide legislative and adjudicative decision-making. And these settlements are intentionally placed beyond the reach of ordinary politics in order to provide a stable and lasting framework for common life. And like all law, a constitution is intended to guide the choices and actions of those subject to it. Law's subjects, not primarily lawyers or judges or governments, but persons and their associations. Law's subjects use the law to figure out what their obligations are, what proposed courses of action are open to them, and how to accomplish whatever changes in legal relations they set out to change. And governments, like individuals, are also guided by law, but more fundamentally and from the Constitution, which is a source of both government power and limits on that power. Now, judges only arrive on the scene much later, if at all, after some action has already been taken, a statute's been passed, or some executive decision made, based on an understanding of what the Constitution permits. So judicial review of legislation or executive action only occurs in response to some primary act of another branch of government, an act of lawmaking or law applying that was paradigmatically conceived to further the common good in some respect. It would have been guided in some measure by an understanding of the Constitution and the whole body of existing law. And judicial review of legislative and executive action for compliance with the Constitution is, in this sense, only secondary. Acts of legislation in a mature and healthy democracy proceed from background understandings of what legislative options are permitted, prohibited, or in some instances required by the Constitution. And this is one of the background themes of the legislative rights volume that Professor Eakins mentioned earlier. So this is the case not only in those jurisdictions that formally require that Parliament be provided with a report addressing the constitutionality of proposed legislation, but in all cases where legislators legislate in good faith and for the common good. And in legislating with a view to the common good, the conscientious legislator is not predicting, as say an American legal realist might, how a reviewing court might view the legislation. The legislator's analysis is conducted in the first person. The analysis is informed by legal doctrines, but it's a matter of selecting means to achieve certain goals that are themselves selected because they further human goods held in common. The legislator makes an independent assessment of whether this series of means and ends is consistent or inconsistent with constitutional commitments. Now, this is obviously the case where a legislator is applying multifaceted and open-ended constitutional criteria to novel questions. But it's also the case where the legislature concludes that the court's current jurisprudence on what the Constitution prohibits is in some important respects mistaken or a wrong turn. And courts can take wrong turns. The practice of apex courts in overturning their own precedents is some evidence of that. The nature of these wrong turns is not usually described as a matter of faulty legal reasoning or technique. Instead, these changes in direction are often explained as having been compelled, or at least invited, by more recent developments in the law, or the exigencies of new factual situations, including social change. In such instances, the decision overturned is not expressly rejected as having been wrong at the time it was made, but because it is now normatively unsatisfying, given other legal commitments. A judicial review for constitutionality should thus never be mistaken for a mere technical exercise, as though courts engage in nothing more complicated or controversial than proofreading. Judicial review is unavoidably normative, and although judges sometimes describe judicial review in technical and almost mechanical terms, like measuring a statute against the requirements of the Constitution, constitutions are not typically written in a manner that allows for purely technical reasoning. Judicial statements that the Constitution compels or requires particular results should therefore be read with some caution. This style of expression may inadvertently obscure the extent to which the matter in question remained open prior to judicial choice. Judges do not have access to some Archimedean point from which they can access the true content of the Constitution that's unavailable to others. The idea that the legislature can legitimately disagree with judicially articulated constitutional doctrine, whether the perceived error is ancient or more recent, should not be controversial. The idea that the legislative, executive, and judicial branches of government have coordinate authority to interpret the Constitution, and courts do not possess singular authority, is a long-standing principle of political theory. And although it's most strongly associated, perhaps, with Abraham Lincoln, it has significant support in both contemporary practice and in the academy. Canadian parliaments, for example, have periodically responded to judicial invalidation of legislation by reenacting similar successor legislation, and that legislation has been upheld by the courts on subsequent challenges. And furthermore, the Canadian Constitution also makes express institutional provision for one particular exercise of coordinate authority through the use of Section 33 of the Charter, the so-called notwithstanding clause. By invoking the notwithstanding clause when legislating, the federal parliament and the provincial legislatures are thereby each provided with the express power to immunize legislation temporarily from judicial scrutiny, as to whether it complies with several of the enumerated rights in the Charter. The second brief meditation I want to offer is on a conceptual distinction familiar from English contract law and popularized in the constitutional context by American constitutional scholars such as Lawrence Solom and Keith Whittington. And this is the distinction between interpretation and construction. It's an extremely important concept, much overlooked, and provides the resources to resolve much superficial disagreement over the authority of judges to change the Constitution. The distinction presupposes that written constitutions are intended to lock in agreements or settlements, and that amendments can only be made according to the exacting requirements of amending formula. An amending formula, at least in the Canadian context, make the process of change extremely difficult, requiring broad consensus. Now, interpretation in this schema has a narrow and technical meaning. Interpretation is a question of fact, it's an act of retrieval, it's a matter of ascertaining the semantic meaning of words that are used in context. This exercise presupposes that the meaning of the text is fixed at the time it was made. No amount of subsequent linguistic drift or changes as to how we use the words can be used to alter the settlement that was locked in at the time of enactment. Now, interpretation is a necessary first step in legal reasoning with the Constitution, but it's not everything. In some instances, it does not do much work at all. And although it's always the first step, no one, judge or legislator, who is seeking to reason with the Constitution can stop at the first step. It must proceed to construction. It's a matter of taking the text as interpreted and situating it among other legal propositions to create doctrinal rules that can be applied to particular disputes. So to take one home example, the first section of the Canadian Charter of Rights and Freedoms provides, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, interpretation is a matter of determining the limits of what has been settled by the words used in context. The words used here in Section 1 are fairly general, but they're not entirely open-ended. What limits on rights can be justified by the fact that one lives in a society? First, we need some background understanding of what a society is. The text here gives some direction. In this context, it's a free society, a democratic one. And it's not a society conjured out of nothing without a history. It is this specific society, extending through time, that produced this constitutional settlement over the course of making many other self-constituting acts over hundreds of years. So we have patterns of behavior and institutions emerging out of hundreds of years of history from which to take some guidance. An early charter jurisprudence of the Supreme Court of Canada emphasized the charter's continuity with the past, such that the rights enumerated therein had to be, quote, placed in their proper linguistic, philosophic, and historical context. It's from the Big M Drug Mart decision in 1985. So the settlement to which this text bears witness easily rules out limits and justifications that might obtain in societies without free markets, or with an attenuated commitment to respecting the dignity of all persons, or with limited regard for autonomy, privacy, or private property. Stated positively, the settlement includes the limits and justifications needed to preserve the type of society that generated the Charter in the first place. But interpretation of general terms will only go so far, and then we enter into the construction zone. And so it is that in the Oakes case in 1986, I believe it was, the Supreme Court of Canada offered a doctrine or legal test which it cobbled together from ECHR jurisprudence. It was a little bit late in acknowledging that. It cobbled together a test for determining the circumstances in which a limit to a person's interests are justified. This is the Oakes test, which separates the question of whether a person's interests are limited from whether that limitation is justified using a proportionality test. The Oakes test is a constitutional construction on the schema that I'm using. It was not mandated by the language of Section 1 or entailed by it in any way. The court could well have developed some other doctrine to give effect to limits on rights. It could have, for example, concluded that reasonable limits are inherent in the nature of the rights themselves, rather than being something external to the rights. And the court could, in the future, permissibly abandon the Oakes test in favor of some other doctrine, and thus change Canadian constitutional law, without having changed the constitutional text or the settlement behind it. Construction is inevitable if one is to reason with a constitution. Very few constitutional provisions are written with sufficient particularity that little or no construction is required. Wherever the text is interpreted and combined with judicial doctrine, or applied to particular facts to yield a rule, this is construction. Although it's a much more creative process than interpretation, construction is nevertheless bounded. It must be consistent with the interpretation of the text, and it may not be used to subvert or undo the settlement. And although the example of construction that I provided was a judicial construction, construction is not a judicial preserve. Every act of legislation is, to an extent, a specification of rights that are articulated in the Constitution. As Professor Gregoire Weber from Queen's University in Canada has argued, the Constitution only goes so far. The rest is left to the legislature as it struggles with the limitation of underdetermined rights. So constructions can be improved and amended either in response to a perceived conceptual error or in response to new factual circumstances. They are revisable. Settlements, however, are not revisable outside of the formal amendment process. Interpretations can be mistaken, corrected, but a court may not set aside an existing constitutional settlement and replace it with a settlement it believes the framers ought to have made, but did not make. This power may not be assumed legitimately under the mantle of interpretation. So with these concepts in mind, coordinate in interpretation and the interpretation-construction distinction, I'd like to consider a challenge posed by the dominant constitutional methodology of the Canadian courts. This is the concept of the Constitution as a living tree. So Canadian constitutional theory takes its central metaphor from a 1929 decision of the Judicial Committee of the Privy Council, Edwards in Canada, a decision much better known as the Persons case. The metaphor involving a living tree is rather better known than the decision itself, which, like the Magna Carta or Blackstone's commentaries, is well known in principle but tends to go unread by teacher and student alike. In its simplest formulation, living tree constitutionalism is understood as the proposition that courts have plenary jurisdiction to adapt the written constitution to meet changed circumstances. And stated at this level of generality, it subsumes several propositions, some of which are sound and some are unsound, and they need careful separation. Not all theories of living constitutionalism are the same. There are more or less supportable versions. Similarly, the theory of constitutional interpretation, thought to be its polar opposite, originalism, is in reality a family of theories with its own more and less supportable versions. The more supportable versions of each, as some scholars argue, and I agree, draw close to each other in important respects and are perhaps indistinguishable. The relationship between these two families of interpretive theory and their place in Canadian constitutional law is a difficult question, but it's one that the Canadian Legal Academy has casually dismissed. The language of living constitutionalism and originalism is, in many circles, extraordinarily divisive and often proves to be an insurmountable barrier to careful and disinterested scholarship. And unlike the United States, which has benefited from an explosion of energetic debate on methodological questions in constitutional interpretation, the Canadian Legal Academy has spent nearly 40 years not so much wandering in the wilderness as standing motionless before a set of unchanging traffic lights. Now, there are explanations for this lack of interest in methodological questions. One cause is the perceived association, whether justified or not, between originalism and the American political right on the one hand, and living constitutionalism and the political left on the other. A more proximate cause is the Supreme Court of Canada's overt denunciations of originalism. However, as I argued in a paper in 2011, the Supreme Court of Canada's grasp on theories of constitutional interpretation is largely stuck in the 1970s. It is true that the Supreme Court has stated unequivocally that it rejects originalism, but its understanding of originalism is anachronistic. You can think of it as bell-bottom originalism. What it has rejected are the tenets of one school of originalism that have also been rejected by most contemporary originalists, namely that we ought to interpret constitutional texts by inquiring into the subjective intentions of the framers, and in particular by asking how the framers would have intended the Constitution be applied to discrete disputes. But a more common originalist method, which has been dominant since about the mid-1980s, is what has become known as original public meaning originalism. Like the theory of original intentions, it's concerned with settlements and posits that the semantic meaning of a constitutional text is fixed at the time of its enactment. But it parts company with the intentionalists over how one determines what a text meant at the time it was adopted. Instead of asking what the framers intended, relying perhaps on external evidence of debates and memoranda, or personal recollections of persons who were present in some capacity, public meaning originalism focuses on the text. The public meaning of the words in context, that is, how an educated reader would have understood the text at the time it was authored, is what is to govern, not the intentions of the framers, or the counterfactual of how the framers would have addressed certain questions had they thought of them. And this last point is significant. Originalist constitutional interpretation is premised on the finiteness of constitutional settlements. It takes as axiomatic the proposition that if a constitution is silent on some issue, that is, if there is nothing in the settlement that resolves some controversy or provides criteria or direction as to how some other institution is to resolve it, then the matter remains with the legislature as a matter of non-constitutionally constrained choice. So at its most basic, originalism is a commitment to two core propositions. First is what's been called the fixation thesis, that is, that the linguistic meaning of a constitutional text is fixed at the time it's made. And second, the constraint principle, which states that the fixed semantic meaning must constrain constitutional practice in some way. Now, of course, there's a lot more to it than that, but the key point with respect to judicial reasoning is that where constitutional debate yielded a settlement or an agreement, and that agreement has been reduced to writing in a manner capable of being understood, the judiciary is not free to substitute some new constitutional provision in place of the one actually agreed to, and is constrained by the actual settlement reached. Now, this formulation leaves much up in the air. What happens when a provision uses general language? perhaps in order to paper over a large degree of substantive disagreement among the drafters and ratifiers. The language used in bills of rights is often deliberately general or underdetermined. In such cases, the contribution of interpretation is quickly exhausted, and there's no point in demanding more from the text than it can provide. But as I stated earlier, legal reasoning is not exhausted by the more or less technical task of textual interpretation. Once the linguistic meaning of the text is ascertained, a constitutional interpreter, whether governmental or judicial, has the task of creating secondary rules to resolve the vagueness, to create constitutional rules to fill in the gaps and to make choices where those choices are legitimately left to the interpreter. Apart from the constraint that the construction can never contradict the text, and the caution that constitutions are finite settlements and not intended to resolve every political question, little can be said in the abstract about constraints on construction. Construction is highly contingent on the needs of a political community, and particularly on the previous commitments that can be ascertained, including past decisions that considered and ruled out possible constructions. In the Canadian context, to draw another example, it's sometimes proposed in academic argument that the right under Section 7 of the Charter to life, liberty, and security of the person should be construed as giving the judiciary the power to define and protect either property rights or economic and social rights. Now, it's uncontroversial that there are no provisions in the Charter expressly addressing either of these sets of rights. To determine whether a right to either or both could be constructed from an interpretation of the text of Section 7 on the methodology that I'm proposing, it would be relevant to ask, for example, whether the inclusion of such rights in the Charter was ever considered, whether such a proposal was rejected, and whether that rejection should be understood as forming part of the constitutional settlement. So this is a simple sketch of the dominant form of contemporary originalist interpretation. And now I want to turn to an argument that demonstrates, I think, how much it has in common with the methodology followed in the Persons case, which is understood in Canada as the prototype of living constitutionalism. And if I'm correct about this point, that the central commitments of living tree methodology are consistent with contemporary originalism, then living tree proponents, whether scholars, lawyers, or judges, have much to gain by attending to and perhaps adapting the substantial analytical resources that have been developed over the last 30 years or so by originalist scholars. So quickly, a bit of legal history. At issue in the appeal of the Persons case to the Privy Council was whether Section 24 of the British North America Act, which has subsequently been renamed the Constitution Act of 1867, whether it permitted the Governor-General of Canada to appoint women to sit in the Senate. The Supreme Court has said it did not, and that the text of the Constitution provided for the governor to appoint, quote, qualified persons, and that qualified persons in this context was clearly intended in 1867 to indicate men only. It would have been unthinkable, the Supreme Court said, for the framers of the Constitution Act of 1867 to have intended otherwise. Lord Sankey, writing for the unanimous panel on appeal to the Privy Council, rejected this method of analysis and the conclusion as well. But before proceeding to a brief exegesis of the method he actually followed, it's important to dispel a perennial myth about the judgment, myth I've been trying to dispel for many years quite unsuccessfully. The dominant narrative of the decision, one that's duly handed down in every law school across the country from professor to student since the late 70s or early 80s, which is wholly erroneous, is this, that first proposition that Section 24, by referring to persons, evidenced a constitutional settlement that women be ineligible for appointment to the Senate, but that 2, social circumstances had changed by 1929, which is when the judgment was handed down, and this original settlement was now plainly iniquitous, such that 3, the judiciary was authorized to set aside this settlement and reauthor the text so that persons would now indicate male and female persons. Now, this line of reasoning is wholly absent from Lord Sankey's reasons for judgment. And to the contrary, he expressly stated that, quote, in any code where women were expressly excluded from public office, the problem would present no difficulty, no interpretive difficulty. He would know exactly what he was dealing with. So if there had been a clear statement of constitutional settlement excluding women, the court would have been bound by it, regardless of whatever change in circumstances had occurred in the meantime. Now, whatever Lord Sankey's views of the equities of the case, he maintained the careful discipline of reasoning from authoritative legal sources. And the analytical method on display in the person's case is concerned, in the first instance, with retrieving the settlement evidence in the text. It's entirely concerned with ascertaining the meaning of persons fixed in 1867, not in 1929 or any other time. The court's concern, he said, was not the counterfactual, what may be supposed to have been intended, but rather what's been said. And like the Supreme Court, Lord Sankey noted that the ordinary meaning of the word persons denotes both male and female persons, but that in some usages it can also be restricted to male persons. But whereas the Supreme Court resolved the ambiguity by appealing to the counterfactual supposition of what the framers would have intended had they actually addressed the specific question, Lord Sankey went to the text. And specifically, he noted that some sections of the Constitution Act used persons to denote both male and female persons, while other sections referred specifically to male persons. And unlike a contemporary living constitutionalist might have done, Lord Sankey did not at any point address the question of what persons meant in 1929. He was fixed on what the word meant at the time the Constitution Act was enacted. And so it's unsurprising, to me at least, that he drew support from the mechanism by which John Stuart Mill proposed in 1867 to secure voting rights for women in the Representation of the People Bill. It was to replace the word man with the word person, understood as a more inclusive word. So with its focus on the meaning of the text, the rejection of original intent, and embrace of original public meaning, this judgment, which is ground zero of living constitutionalism in Canada, is a judgment that could easily have been penned by Antonin Scalia, without the sarcasm, perhaps. So how, then, did living tree constitutionalism develop in Canada? It didn't emerge until 50 years later, in judgments contemporaneous with the European Court of Human Rights' first articulations of living constitutionalism. And the person's case lay largely dormant until the Supreme Court of Canada pressed it into service for interpreting the new Charter of Rights and Freedoms. And in an early judgment, the court harnessed a passage in which Lord Sankey stated over the course of a meditation that the need to give a Constitution Act a large and liberal interpretation. The Constitution Act of 1867 planted in Canada a living tree, capable of growth and expansion within its natural limits. Okay, it planted in Canada a living tree. This is the metaphor that swallowed the decision. The passage from which the metaphor was taken is almost invariably misquoted. It's kind of like that great Bob Dylan song, "The ants are my friends, they're blowing in the wind." You think about it. Lord Sankey does not say, as later judges take him to have said, that the Constitution is itself a living tree. Rather, the passage is that the Constitution Act planted a living tree, and the difference is significant. The Privy Council's decision has to be situated in the politics of the time. The decision came down in between the Balfour Declaration of 1926, the Statute of Westminster in 1931, and it can be taken as an expression and confirmation of Canada's constitutional independence. The occasion of the Constitution Act of 1867 was the decision of former colonies of Upper and Lower Canada to unite with Nova Scotia and New Brunswick to form the new Dominion of Canada. And the purpose of the act was to grant a constitution to this new political community. It would delineate the legislative authority of the federal and provincial governments, as well as establishing the institutions of government. So the tree planted by the Constitution Act of 1867 is primarily the new political community that is the Dominion of Canada, and only secondarily the institutions that govern it, including its constitutional law. It's the Dominion that will grow, and the constitutional doctrine that will grow with it. The settlement, however, remains fixed. There is, of course, a sense in which the Constitution does grow, although the text remains what it is. As Lord Justice Sankey continued, the object of the Act was to grant a constitution to Canada, and like all written constitutions, it's been subject to development through usage and convention. And the methodology of the person's case is therefore easily reconciled with developments through usage and convention, as well as the Supreme Court's later repeated insistence that constitutional concepts not be frozen in time. The key is the distinction drawn earlier between constitutional interpretation and construction. When it comes to questions of interpretation, and the strict sense of ascertaining what the bargain was, what the settlement was, this is simply a matter of reporting the facts. There's no room for courts to improve on it. Setting aside or otherwise amending a constitutional settlement is a failure to keep faith with all those who participated in the process of constitution making for the common good, people who were assured that the process would bind. It's not the judicial role to replace the actual constitutional settlement with another provision reflecting some better political or social arrangement, or as Lord Sumption characterized the practice of the European Court of Human Rights, the court's view of, quote, what is appropriate to a democratic society. Constitutional construction, however, is on a different footing. Where a political community is faced with changed and unanticipated circumstances, as all communities are continually, the problem arises as to how the new phenomenon, be it technological or social, how the new phenomenon can be addressed under a constitutional settlement that did not anticipate it. It's a matter of providing answers to new questions, such as where to allocate jurisdiction, federal or provincial, over aeronautics, nuclear power, cellular data. This is gap filling of the justum generis variety. And further, where a constitutional provision incorporates a moral principle, a judge is required to determine what the principle actually requires, subject to what other constraints the law imposes, and not what the founders believed it to require. The limits to genuine construction are particular to specific constitutional settlements, but there are some limits that can be stated generally. One such limit is that construction cannot be used to provide new answers to old questions already settled by the Constitution. Much turns here on what's understood by settlement. It's broader, it seems to me, than just what's included in the text. It could also include, negatively, constitutional proposals that failed and other deliberate omissions. What it does not include is arguments of the type accepted by the Supreme Court of Canada in the Persons case but rejected by the Privy Council. The counterfactual that had the framers squarely addressed some question, which they did not, they would have resolved it in a particular way. The Constitution does not include provisions that might have achieved unanimous support had anyone thought about them at the time, but that no one proposed, discussed, or voted upon. So there is some truth in the claim that the Constitution is not frozen. Where there are modest gaps or vagueness or irresolvable ambiguity, there is room for construction. That is supplementation and development of constitutional doctrine. But this claim must be separated from the unsound claim that nothing in the Constitution is beyond the revising pen of the judge. And I think no serious proponent of the Canadian variant of living constitutionalism advocates such a proposition. What is settled is settled. To be sure, we must not understate the difficulty in ascertaining what's settled. Sometimes settlements are deliberately incomplete and the answer sought won't be there. But we must not overstate the difficulty either. There's often a settlement in some respect, even if it is incomplete, and this will sometimes be enough to dispose of a dispute, or at least to foreclose some proffered interpretation or construction. Where such a settlement exists, it's appropriate to call the Constitution, to that extent, fixed, frozen, what have you. Although the Supreme Court of Canada appears from time to time to insist otherwise, I think this is a semantic infelicity that should not be understood as denying the bindingness of constitutional settlements, but allowing rather for the possibility of constitutional construction. The Canadian Academy, however, remains unconvinced, and typical is a contribution to the recent Oxford Handbook of the Canadian Constitution from Oxford Professor Timothy Endicott and Professor Peter Oliver. They begin, quote, a theory of living tree constitutional interpretation allocates power to judges to change the Constitution, close quote. Now, this statement is supportable, it seems to me, to the extent that the concept of change is understood as limited to construction only, and the reference to the Constitution is not a reference to the settlement recorded in the text. But then they carry on to state, without apparent concern, that the state of living constitutionalism is such that judges may change the Constitution without, quote, any articulate doctrine specifying the distinction between sensitive and sensible interpretation of the Constitution, on the one hand, and unconstrained constitutional creation or construction masquerading as interpretation on the other, close quote. Now, Endicott and Oliver are, it seems to me, entirely too sanguine about living constitutionalism's neglect of doctrinal guidance for judicial constraint. Constraint, however, is a subject of much interest to constitutional scholars who study originalist constitutional theory. And if, as I've argued, the Canadian variant of living constitutionalism is compatible with much of this theory, then what is needed in Canada may be supplied by attention to originalist scholarship. So to sum up, the neglect of constitutional methodology and constitutional interpretation in particular risks disregard for constitutional settlements. And that disregard may stem from the best of intentions, the belief that a better, more just, more equitable settlement is available, that this new settlement would be an undeniable benefit to the political community now, and would surely now be chosen if the circumstances for amendment were more readily available, and that the political community should not be denied this benefit now simply because of the limited foresight, imagination, or even moral clarity of a previous generation of constitution makers. But if a community manages to coalesce around a framework for governance, courts are vested with the responsibility of understanding the agreement and applying it. Living constitutionalism is an incomplete interpretive methodology that does not give adequate guidance to judges. Constitutional interpretation will never be uncontroversial, but it can, it seems to me, benefit from a more robust methodology that provides greater guidance and leaves less to the discipline and virtuosity of individual judges. Thank you.
We have time for questions and comments, and I'll invite them in just a moment. And of course, you may ask whatever you please. I should note, of course, that Justice Miller is a serving judge, and if a question does pertain to something that may come before the Court of Appeal, he may have to simply not answer. But don't let that put you off. Ask what you would like, and we'll see how we go. So, please.
Warwick Light, I work at Policy Exchange. I'm an economist.
Hence the question I'm going to ask you. In the United Kingdom, as part of our relationship with the European Union, we found that our courts on occasions have got into economic questions that perhaps you wouldn't normally expect to be considered in a forensic setting, complex trade-offs about the structure of employment and so on. Robert Sharp is an old friend of mine, and he's assured me that although the economic rights that you allude to under the Charter of Rights are there, they've never really taken off in Canada, and the courts in Canada have been very cautious and reserved about going down and exploring those kind of trade-offs that maybe a parliament or a government department might do. And I just wonder what your take on the Canadian experience of those economic and social rights might be.
Thank you. Well, I would agree with the latter part of your statement that they have never taken off in Canada. On the one occasion in which the question was squarely put to the Supreme Court of Canada, the claim was dismissed. Some uncertainty was injected into the waters when the court said that something to the effect of now is not the time, leaving open the question of whether there ever would be a time, which again, I don't take anything to be settled by raising the question or not raising the question, but that's where the matter has been left at the apex court. The courts of appeal of the various provinces have not, to my knowledge, ever taken up the question. If they had and resolved it in the creation of new economic and social rights, that would have proceeded to the Supreme Court of Canada, and it hasn't. As far as the preliminary statement of my colleague Justice Sharp assuring you that they're in the Constitution, I offer no opinion whatsoever.
Further questions? So, gentleman back here. Thank you. Here.
Greg Walker, thank you very much for a very insightful lecture. I found it very interesting. Can I ask, you seem to pin your colours to the mast of original public meaning, originalism. Does that mean that you would sort of reject or not accept Richard Eakins' understanding of legislation as a part of collective intentionality of the legislature, and that should inform the interpretation of constitutions or legislation more generally? Are you rejecting that sort of understanding, or and going down the Keith Whittington line more clearly, or do you see there's a lot of compatibility between the two positions?
Yeah, actually, I've used Professor Eakins' work quite a bit, both in my writings as a scholar and as a judge. So I understand what he thinks to be relatively compatible, although I've also been told that I have no real insight into my own thought processes. So the original intention business is sort of restricted to the idea that you can use kind of other evidential means of what's going on in the subjective intentions of persons. Professor Eakin's work, as I understand it, is heavily textualist. He is premised on the belief that the intentions can be expressed through texts, and there can be such a thing as a group intention of a body of a legislative deliberative body, which is something that I agree as well. It may well be that it's more useful to talk, because of so many disagreements and misunderstandings surrounding living constitutionalism and originalism. I sometimes wonder if it's more productive just to talk about constitutional settlements, because that tends to be something that everyone can kind of coalesce around. If there has been an agreement made according to the rules that we have for making such things, then that bargain should probably be honored. It's easy to get assent to that proposition, rather than spending a lot of time fighting over what the commitments of originalism or living tree theory are.
Let me just say, maybe the question might be partly how public meaning is determined. That's all I'll say.
No, you jump in.
Well, I'll say further then that there was one interesting and quite useful book review of my book, which did refer to the thesis as though it were intentionalism that Justice Scalia could love. So there is an overlap in terms of how one ascertains the settlement at the time, I think, and how broadly one can depart from the text in its context. Other questions? Please. Microphone's on the way.
I'd like to ask a less technical question. You practiced a long time in constitutional law, amongst other things, and now you're a judge, an appellate judge. Has your view about judicial power altered between in these various different capacities you've had?
I would say that it has. And I wouldn't care to elaborate.
Read the judgments. Further questions? Please, the microphone's coming soon.
I was very attracted by your suggestion of coordinated responsibility for constitutionalism between the executive, the parliament, and the judiciary. And I wondered if you would agree that if there's lots of constitutional construction going on, that might be an indication that the restrictions on the political capacity to amend the Constitution are too tight.
Well, no, I think that it's... I don't know that a Constitution can function well at a level of great detail. So if we're amending the Constitution every year or two, and it's running to 150, 300 pages, that really has, and some countries do that. Their constitutions are quite easily amended, and they're amended often, and that they're very, very lengthy documents. That's not been our way. It's not the tradition of law that we have. Constructions are going to be inevitable, no matter how specific you try to get the constitutional text. You just can't get away from it. Every act of legislation, take one simple example, whenever an ordinance is being drawn up for the use of a park or something like that, there has to be in the background some conception of freedom of expression, freedom of association. What do these concepts mean? What do they require? And so certain things don't ever get on the table when the ordinance is being drafted, because the drafter is engaged in construction, cashing out specifically what does a commitment to freedom of expression mean in the society? What does a commitment to freedom of association mean? And then it's worked out in public. Now that can be brought to a court and demand made for an assessment of it on some unlimited bases. But I don't think that's can ever be taken away. I mean, again, it's just the nature of lawmaking.
Please.
Thank you very much, and thank you once again for a most interesting discourse. Keith Best, I'm a member of the bar. It seems to me that there has been in many jurisdictions a development or a melding together of the differences between a strict interpretative basis and a purposive basis of interpretation of constitutions. I mean, is this something that you've experienced or see outside Canada? And do you think that actually this is the way in which many jurisdictions are actually now going to actually trying to sit upon a compromise between what in essence are two really rather incompatible ways of looking at constitutionalism?
Yeah, no, I think that's a very good insight, and certainly it is something that we see in Canada, that there's it might be fair to say, at least in Canada, that although the Supreme Court invariably describes itself as adhering to living constitutionalism and a purposive style of interpretation, in fact, I think if you just sort of strip away the description of what it's doing and look at what it's actually doing, it can be quite different. It can be quite eclectic. And it picks and chooses, not on the, I don't know on what basis, but it is very eclectic. In some instances, the court will go very hard on textualism. It will overturn previous living constitutionalist precedents on the basis that no, this is what the framers actually intended, and we'll have a wholesale revision of law. So there's this continual battle going on. Not just, and not primarily among judges sitting on the same bench, but in the heads of the individual judges themselves. And one will, and some judges who are very self-aware will say, well, there's wrong with that. That's just, we don't actually need to pick one horse and ride it. We can switch back and forth as we choose. Now, to what extent that obtains in other countries, I'm afraid I'm not a good enough comparativist to give you an answer on that one. But perhaps Richard,
I won't
you're
answer that
standing here. So no, yeah.
Other questions? No? Well, let me invite Lord Sumption to give a vote of thanks to bring our meeting to a close. Lord Sumption.
Living trees is a metaphor. And the problem with metaphors is that they promise a great deal more than they can deliver. This one has always had at its heart a basic ambiguity. Are we talking about the principle on which the law can be said to refer to values which are themselves inherently changeable? For example, what is a cruel and unusual punishment? Or perhaps, what kind of beings are we referring to when we talk about persons? The other approach is to treat a body of law as a body of principle from which you can extrapolate so as to create new rights on the basis that the kind of people who formulated the existing rules would no doubt have been very satisfied with the new ones as well. The first of these processes is essentially interpretative, whereas the second is essentially legislative. All constitutional judges face this dilemma, and most of them engage in one or other of these processes at different stages of their judicial lives. That is why it's extraordinarily interesting to have the views of a distinguished constitutionalist from another jurisdiction, in particular a common law jurisdiction and a jurisdiction with a rights-based constitutional settlement. And it's certainly why I'm sure I speak for everyone present in thanking Judge Miller for an extraordinarily perceptive and original contribution to a debate which has always been in progress and will no doubt always will be.